Hello and welcome to Legal Briefs. Today we have something very special for you because we have reviewed the legal memos recently unsealed in the Ripple versus SEC case, and at the end of this video you are going to know what Ripple was told back in 2012 about its sales of XRP. But wait, there's more, because in the legal world there's always two sides to the story. I will be calling on the infamous Thien-Vu Hogan to step in and argue Ripple's side, which means I will be arguing on behalf of the SEC. Don't hate me, I drew the short straw. And then at the end of our argument, you can vote on whose argument was better by sending 100 XRP to the loser, which will probably be me. But wait, there's more! As an added bonus, we will be wrapping our legal arguments to our favorite Run DMC songs. Okay, just kidding about that one. Welcome back, and without further ado, here's the order from Judge towards unsealing the documents, and it looks like a lot of documents, but it's not really a lot of documents to be seen from this unsealing because many of the entries were redundant or not important, kind of like the packaging of cereal. Looks big, but it's small. Now, I went through all of these documents that were unsealed, and really the only new things in there are the unredacted SEC response to the Larson and Garlinghouse motions to dismiss, the two legal memos, and an email related to the memos. So, without further ado, let the battle begin. Boom! There she is. Now, Thien-Vu will be arguing for Ripple. I will be arguing for the SEC. As a lawyer for the SEC, give me a second to get into character. Yes, Emperor, I am ready. And as a polite Dark Lord of Hell, ladies first.
May it please the court. In support of Ripple's fair notice defense, the defendant enters into evidence by joint stipulation the legal memos from the law office of Perkins and Coie, dated February 8, 2012 and October 19, 2012. As these memos make clear, the state of securities law from 2012 at least up until 2018 was in a state of utter confusion as pertained to digital cryptocurrencies. No one in 2012, no one, not even one of the top law firms in the country, knew how to apply the law to an asset class that was only 3 years old. Even considering the state of utter legal uncertainty surrounding the time frame from 2012 to 2018, what the unsealed legal memos do make clear is that Ripple was provided legal guidance, that its amended business strategy in dealing with XRP put it at minimal risk of it being in the exact same situation it currently finds itself in, an SEC enforcement action. And I say amended business strategy because the earlier February 2012 legal memo addressed Ripple's initial business strategy, and this is what it said about the initial business strategy. Looking at the second page, Roman numeral 3, paragraph A. If sold to investors who provide founders with the capital necessary to launch and operate new coin, which later became Ripple, the coins will likely be considered securities and subject to regulation under federal securities laws. So Ripple must have just ignored this advice and moved forward anyways, right? No, in fact, Ripple instead took this advice and came up with a revised business plan, which included not making sales of XRP to individual retail purchasers, but only to wholesale exchanges, and instead focused on obtaining private equity funding in order to build out the XRP ledger. And then, after making those changes to its business plan, Ripple went back to the law firm and received the October 2012 memo. And here is what that memo concludes. Looking at page 4, we believe that a compelling argument can be made that Ripple credits, which would become XRP, do not constitute securities under federal laws. Given the lack of applicable case law, we believe there is some risk, albeit small, that the SEC disagrees with our analysis. Well, now as we know, the SEC did not disagree with that analysis and did not state that XRP was a security despite knowing exactly what Ripple was doing with XRP, all the way until it filed the lawsuit 8 years later. And then going back to the memo for a minute. Later in the memo under the legal analysis section, the memo states, we understand that the primary reason for purchasing Ripple credits, XRP, is to facilitate online commerce, not to engage in speculative investment trading. As such, given the commercial nature here, Ripple credits, which is XRP, should not be considered securities. And so, Judge, Ripple followed the legal advice contained in the October 2012 memo to a T. And later in 2018, Director Hinman's 2018 speech actually reinforced this legal opinion that Ripple had been provided 6 years prior. And then it reached out and discussed what it was doing with the SEC and was never told by the SEC that it was doing anything illegal. And all of the guidance that it had received up to that point suggested it was not required to register with the SEC. For 8 years, Ripple acted in the belief it was behaving lawfully until the lawsuit was filed in December 2020, the last day of Chair Clayton's tenure at the SEC, after more than 8 years of business. And that scenario, Your Honor, is the textbook definition of a legal lack of fair notice. Thank you.
Damn, that was good. Okay, here we go. Judge, first, let me begin by pointing out that the focus of the fair notice defense is not on what a law firm that the defendant paid for legal advice says in a memo. It's whether the law puts a reasonable defendant on notice that its actions are illegal. And we believe that the Howey test and its 60 years of progeny are very clear. In fact, the October 2012 memo references the Howey test as controlling precedent. Now, putting aside the self-serving pieces Ripple wants to highlight, I would like to direct the court's attention to the following language from the October 2012 memo. Looking at the second paragraph of page 17, quote, Ripple has a greater risk of being seen as a common enterprise and therefore be selling a security because there will be a specific entity which is responsible for the distribution of XRP and the promotion and marketing functions of the Ripple network, close quote. Further, the memo noted importantly that the risk of a security designation could be lessened if, quote, neither the founders nor Ripple will be collecting or retaining funds from the distribution of XRP, close quote. And obviously Ripple has, and even in the face of this litigation, has continued to collect and retain funds from distribution of XRP, knowing that doing so puts it at even greater risk, and indeed has led it to make illegal sales of unregistered securities. So it seems that Ripple not only ignored the danger implicit in its sales of XRP, but actually ignored the very important advice to not retain funds from the sales of XRP. Not only has it retained funds, but it's retained over $1 billion worth of funds. This is not a lack of fair notice, Your Honor, but a simple failure to pay attention to a known law.
If I may, Judge, in rebuttal, the SEC's main argument is simply a misplaced reading of the October legal memo and Director Hinman's own guidance from his well-published 2018 speech. Ripple's initial business plan was to accept payment from retail investors for sales of XRP. However, after the first February legal memo suggested that it was a bad idea, Ripple changed its business plan and instead raised all the funds to create and implement the XRP ledger from private investors who received shares of the company. This was laid out in the October 2012 memo, right in the middle of page 2. Founder will not accept investment in the company in exchange for the issuance of Ripple credits, i.e. XRP. Instead, investors will receive stock in the company. And that is what Ripple did. And further, this is entirely consistent with the guidance provided by Director Hinman in 2018, in which he analyzed Ether and which speech is still up on the FCC's website. Take a look at it here. It says, putting aside the fundraising that accompanied the creation of Ether, based on my understanding of the present state of Ether, the Ethereum network and its decentralized structure, current sales of Ether are not securities transactions. This is exactly what Ripple did. Ripple used private equity investment to fund the creation of the XRP ledger, and only once the ledger was functional did it utilize any sales of XRP. The SEC can argue all it wants that the XRP ledger is or wasn't functional or decentralized, but that doesn't change the fact that Ripple believed it was and that it followed the only guidance available to it at the time, the legal memos it received in 2012, which contained similar guidance to Director Hinman's 2018 speech. That the SEC now wants to recede from that affirmative guidance is exactly what violates Ripple's Fifth Amendment fair notice rights. Thank you.
I like your robes, Your Honor. Very nice shade of black. When you finish, you should just turn around and slap me. Just slap me, like a TV slap. I'll go, psh.
I just promised you the video, that's it.
Thanks, babe.